Good afternoon, Mr. Larimer.
Good afternoon. Bess?
Well, just wait a minute or two here for the Apprentice Tax Board representative Staitner.
Okay. I'm so pleased we're starting early versus 5 o'clock. When I saw that, I was a little scared that I was going to be standing for a couple hours.
Yeah, well, I'm sure it'll go fine. Hello, Mr. Meridian.
Hello.
Okay. Will there be anybody else attending for the Franchise Tax Board today?
I don't believe so.
Okay. And we'll go on the record here in just a moment. I'd like to go through a couple items before we begin. And if you could both please just mute your microphones right now. Thank you. Welcome to the appeal of Larimer. Again, my name is Seth Elsom, hearing officer Elsom. Before we get started here, just like to ask the parties to test their microphones, which you just did. So I think we're good on the audio. And as a reminder, this is live streamed over YouTube, and this hearing will be available to the public and viewable on OTA's YouTube channel. My name is Seth Elsom, as I stated, and I'll be leading the hearing today. On today's panel, in addition to myself, is Administrative Law Judge Veronica Long and Administrative Law Judge Stephen Kim. While I'm the lead for the purpose of conducting this hearing, all three panel members are co-equal decision makers. As this is a virtual hearing, the hearing will be auto-transcribed. So to speak, please unmute the microphone and remute the microphone when you are finished speaking to avoid feedback and background noise. To ensure that we have an accurate record, we ask that everyone speaks clearly and loudly. Please state your name before you speak one at a time, and do not speak over each other. If needed, I will stop the hearing process and I'll ask for clarification. After the hearing, the official transcript will be available on the Office of Tax Appeals website. The hearing transcript and the video recording are part of the official record for this appeal. Finally, please remember that these proceedings, again, are being broadcast over our YouTube channel, and any information that's shared during this hearing will be heard and or viewed by the public. Before we go on the record, I'd like to ask the parties if you have any questions. We'll start with appellant. Any questions before we go on the record?
I actually did. Dealing with the California Civil Procedures 2025-520, I wanted the ability to read, sign, and review the transcript, especially if it's being auto done, for accuracy to reflect what was actually intended. Is that still available?
We can revisit this a little bit later in the hearing. I'll discuss with the panel members, and I'm not familiar with that particular procedure or regulation, but we'll discuss that, and I'll give you an answer on that before the end of the hearing. Okay. And for the Franchise Tax Board, did you have any questions before we go on the record here?
No further questions.
Okay, thank you. Judges, are you ready to go on the record?
I apologize, I have one more question.
Okay.
Will we be following the 30-40-30 rule of OTA? We're dealing with oral presentations to the public where information like bank name should be probably redacted.
There'll be nothing disclosed here.
Okay.
There's nothing that's going to be presented live. So unless you mention it specifically, you will not need to worry about disclosure.
Thank you.
And also, if there's anything that's posted on our website, will be revised and reviewed for errors with the hearing reporter. And this is an auto transcribed transcript. So we will go on the record now. We're opening the record in the appeal of Larimer, and this is case numbers 2205-10322 and 2211119555. This matter is being held virtually before the Office of Tax Appeals. Today's date is October 9th, and the time is approximately 1:04 p.m. My name is Seth Elsom, and I'm the lead hearing officer for this appeal. With me today is Administrative Law Judge Veronica Long and Administrative Law Judge Stephen Kim. As a reminder, the Office of Tax Appeals is not a court. It is an independent appeals body that is staffed by tax experts and is independent of the state's tax agencies, which includes the Franchise Tax Board. And with that, can the parties please introduce themselves for the record? And we'll start with appellant, Mr. Larimer.
My name is Zoe Larimer.
Thank you. And Franchise Tax Board, can you please introduce yourself?
Good afternoon. My name is David Meridian.
Thank you, Mr. Meridian. And we'll state the issues now. As confirmed at the pre-hearing conference and in my minutes and orders following the conference, there are 5 issues to be decided in this appeal for the 2018 and 2019 tax years. And those are: 1, whether appellant has established error in the Franchise Tax Board's proposed assessment; 2, whether appellant has established reasonable cause for abatement of the late filing penalty; 3, whether appellant has established reasonable cause for the abatement of the demand penalty; 4, whether appellant has established a legal basis for abatement of the filing enforcement fee; and 5, whether appellant has established a legal basis for the abatement of interest. And with that, let's go to the admission of exhibits as evidence. And we'll begin with appellant. As noted in the pre-hearing conference minutes and orders, we renumbered the exhibits that you have submitted through the course of the appeals process as exhibits 1 through 45, and provided an exhibit for those on September 17th in our minutes and orders. And it notified the parties to provide any objections by October 1st, 2025. FTB did not provide any written objections to these to the admissions of these items into evidence. And those items, exhibits 1 through 45, are now admitted and entered into the evidentiary record. Franchise Tax Board has submitted 25 exhibits for the 2018 and 2019 tax year, which were relabeled as exhibits A through Y. These exhibits were submitted by the Franchise Tax Board prior to the pre-hearing conference. And as discussed above, appellant was asked to review these exhibits and indicate in writing whether he had any objections to the admission of FTB's exhibits into the evidentiary record by October 1st, 2025. And appellant informed OTA that he objects to the admission of exhibits B because I believe you stated it was illegal. Mr. Larimer, I just wanted to ask you, can you quickly, I want to check in with you and ask if you can clarify what you meant by this statement and why you object to the FTB's admission of this item as evidence?
I didn't submit that letter, and that information is also what we talked about with, I just talked about with Rule 430, dealing with information and privacy, staying in an oral public record, dealing with transparency.
Okay, so your concern is primarily with the privacy of this?
Yes.
Okay. I'm going to state here that our regulations provide that all relevant evidence is admissible. And because this was a response to the demand for the 2018 tax return, that evidence, we're going to allow that into the evidentiary record, and we'll consider the weight that we provide to this will be considered given your arguments and your testimony today. And with respect to your concerns about the confidentiality of this item, again, this will not be viewed or discussed unless you bring this up on the live stream today. And with that, we're going to admit FTB's exhibits A through Y into the evidentiary record. And Mr. Larimer, you indicated at the pre-hearing conference that you plan to provide witness testimony. I will swear you in before you begin your presentation so that any factual statements you make during the presentation or in response to any questions may be considered as evidence by the panel. And we'll do that in just a moment here. And finally, before we get into the parties' presentations, I'd like to quickly go over the time estimates and order of the proceedings today. As noted in the minutes and orders, appellant will present first and will have approximately 30 minutes for his presentation. Following appellant's presentation, Franchise Tax Board will have the opportunity to ask appellants questions regarding his testimony only. The panel will then be given an opportunity to ask any questions they may have for appellant. Following that, Franchise Tax Board will have 20 minutes for its presentation, after which I will turn it over to the panel for any questions they may have of FTB. And then finally, appellant, Mr. Larimer, you'll have an additional 10 minutes for a rebuttal or closing statement. After appellant's closing, I will do a final check with my panel to see if there are any remaining questions for either party. And with that, I believe we are ready to begin. And does either party have any questions before I turn it over to Mr. Larimer for his presentation? Okay. Mr. Larimer, please unmute your microphone. I'd like you to raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I swear.
Thank you, Mr. Larimer. You have 30 minutes and you may begin your presentation whenever you're ready.
Thank you. Good afternoon. Thank you for making an opportunity for me to be heard. I believe the Franchise Tax Board has taken actions against me without legal justification or supporting evidence. I've submitted sworn statements each time the FTB has contacted me and verified my income falls below the filing threshold. I've been respectful, reasonable, and detailed with my communications and my observations. The state confirms my sworn statements in Exhibit G, which fails to acknowledge there is zero income. The use of mortgage interest is not income. The interest equation given in Exhibit H is inconsistent with the FTB's references used in Exhibit 13. Submitting or endorsing false information under oath is a serious matter, and I have provided documentation to verify that my statements are true. In reference to Exhibit B, there is a letter I am incorrectly attributed to submitting. 3 attorneys have participated in this case, each relying on the same inaccurate information. This raises concern about whether due diligence was performed before filings were signed. This case matters because it suggests that the state can disregard sworn testimony without evidence, which conflicts with both California law and constitutional principles. FTB's exhibit ILMNV summarize legal arguments that apply to tax avoidance cases. However, I am not attempting to avoid taxes and have said so consistently. I have provided historical tax filings and interest data in Exhibit 11 that support my sworn statements. The FTB's determinations are arbitrary and not supported by factual data in Exhibit 12. Unlike Palmer or Pollard, I have not filed a frivolous appeal, denied federal tax authority, or made arguments based on constitutional exemptions. My situation is straightforward. I did not earn enough income to require a filing, and I responded in full compliance with state instructions. I'm not involved in any business or activity cited in unrelated cases such as Pet Zolt or Gold Emporium, which involved significant unreported income or third-party evidence. There are no informants, ledgers, or financial discrepancies connected to me enough to enforce a cash expenditure method or the use of correctness. I have lived and worked in California, am single, and do not share income with any party. No evidence has been presented that contradicts my sworn statement. In reference to Honeywell, the court found sufficient evidence to support the trial decision. This case differs in that there is no evidence supporting the FTB's position. I have responded to all FTB notices for tax year 2018 and 2019, fulfilling the requirements under RNTC 19133. There is no indication of willful neglect. The FTB, in fact, provided exhibits confirming my timely filing. Finally, a Superior Court judge has ruled me uncollectible for the years in question in Exhibit 16. This case supports my position that I am in compliance with the law. For these reasons, I respectfully request the OTA review the appeal in light of the evidence and legal standards presented. Thank you for your time and your consideration.
Thank you, Mr. Larimer. Just wanted to let you know that you still have until about 1:40, or does that cover your?
That covers it. I wanted to make.
Okay.
I apologize. It's a brief. I meant to be brief, so
Okay.
I got my point across.
Thank you, Mr. Larimer. So now I'd like to first turn this over to the Franchise Tax Board to ask Mr. Larimer any questions of his testimony only. Do you have any questions, Mr. Meridian, regarding Mr. Larimer's testimony only?
No questions.
Okay, thank you. And I'd like to now turn it over to the panel, beginning with Administrative Law Judge Long. Do you have any questions for appellant?
I have no questions at this time. Thank you.
Thank you. And Judge Kim, do you have any questions for appellant?
Not at this time. Thank you.
Thank you. Mr. Larimer, I don't have any questions for you at this point, and thank you for the testimony and the presentation. And now we're going to turn it over to the Franchise Tax Board for its presentation. And Mr. Meridian, you have 20 minutes and you may begin whenever you're ready.
Thank you. Good afternoon. My name is David Meridian, and I represent Respondent Franchise Tax Board in this matter. FTB initiated this filing enforcement action for the 2018 and 2019 tax years based on Form 1098s it received showing that mortgage interest was paid by appellant. As a result, FTB issued demands for tax return for both tax years, and after correspondence from appellant, FTB issued notices of proposed assessments. For both tax years, FTB issued separate NPAs in which it assessed taxes, penalties, filing enforcement fees, plus applicable interest. Appellant protested both tax years separately, stating that he did not make the income FTB had alleged he made and that he had received public assistance from the state. FTB requested that appellant provide information to substantiate his claims. Because appellant did not provide this information, FTB affirmed the NPAs and issued notice of actions for both tax years, which was followed by appellant's appeal. Before diving into the issues and analysis, it should be stated that the 2018 and 2019 tax years were consolidated by the OTA. I'll now go over the issues of the case for both tax years, followed by the law and analysis. For both tax years, there's 5 issues. First, whether appellant has demonstrated that FTB's proposed assessments for the 2018 and 2019 tax years were in error. Second, whether appellant has established reasonable cause to abate the delinquent filing penalty for both tax years. Third, whether appellant has established reasonable cause to abate the demand penalty for both tax years. Fourth, whether the filing enforcement fee was properly imposed for both tax years. And finally, whether interest may be abated for both tax years. As noted, both the 2018 and 2019 tax years have the same identical issues. As such, we will cover the same issue for both tax years at the same time. With respect to the first issue for both the 2018 and 2019 tax years, appellant has not demonstrated that FTB's proposed assessments were in error. FTB's proposed assessments for both tax years arose from information that FTB had received that appellant had made mortgage interest payments of $15,555 and $13,664 for the 2018 and 2019 tax years, respectively, which triggered a filing requirement. Specifically, under Revenue and Taxation Code Section 18501, every individual that has a gross income or adjusted gross income that exceeds the minimum income levels for a particular tax year must file a tax return. Under Section 19087, if a taxpayer fails to file a tax return, FTB may estimate income based on available information and may propose to assess tax, interest, and penalties. Based on mortgage interest paid in the amount of $15,555 for the 2018 tax year and $13,664 for the 2019 tax year, it appeared that appellant received sufficient income to require the filing of tax returns for the subject years, and FTB estimated appellant's income to be $93,330 for the 2018 tax year and $81,984 for the 2019 tax year, which is equal to 6 times the amount of mortgage interest paid for those respective years. Because appellant failed to file a tax return for both years, FTB properly made an assessment based on available information, namely the mortgage interest paid during the subject appeal year, pursuant to the provisions of Section 19087. When FTB makes an assessment based on an estimate of income, its initial burden is to show why its assessment is reasonable and rational. Here, appellant's mortgage interest payment information is the basis for the reasonable inference that he must have had sufficient income to pay for cost of living expenses, including his mortgage. In fact, FTB studies support the use of mortgage interest payments to estimate income and to establish that its assessments are reasonably and rationally based. The 6-to-1 income to mortgage interest paid ratio to estimated income was not implemented by FTB's filing enforcement program arbitrarily or capriciously, but as stated in much greater detail in the opening brief, was based on a study and is actually very conservative. Accordingly, the study, coupled with appellant's mortgage interest payment information, carry FTB's burden of showing the MPA for both tax years was reasonable and rational, and that it must be presumed correct. As set forth in FTB's opening brief for both tax years, FTB has continuously requested that appellant provide information, including supporting documentation, demonstrating how he could afford his mortgage and other living expenses. Unfortunately, to date, appellant has only made unsupported assertions and has not provided any of the documentation requested by FTB to establish how the mortgage interest payments were made. Therefore, appellant has not met his burden to establish he did not earn taxable income in the 2018 and 2019 tax years sufficient to trigger a filing requirement. With respect to the second issue, appellant has not established reasonable cause to demonstrate that abatement of the delinquent filing penalty for the 2018 and 2019 tax years is appropriate. Specifically, under Section 19131, if taxpayers do not file their return by the applicable due date, FTB shall impose a delinquent filing penalty equal to 5% of the total tax due per month for up to a maximum of 25%. For both tax years, appellant has not filed a tax return. Accordingly, FTB correctly imposed a delinquent filing penalty for both tax years. Appellant has not offered any arguments as to why the delinquent filing penalty for either year should be abated. As such, FTB's actions with respect to the delinquent filing penalty for both tax years should be sustained. With respect to the third issue, appellant has not demonstrated reasonable cause exists for the abatement of the demand penalty. Section 19133 provides that a demand penalty may be imposed when a taxpayer fails or refuses to file a return upon demand, unless it is shown that failure is due to reasonable cause and not willful neglect. The demand penalty is computed at 25% of the amount of the taxpayer's total liability without regard to payments. In addition, pursuant to California Code of Regulations, Section 19133, a demand penalty is proper if it is assessed following the taxpayer's failure to timely respond to a request or demand to file a tax return at any time for the 4 taxable year period preceding the taxable year for which the current demand was issued. For the 2018 tax year, FTB properly assessed the demand penalty on the NPA because appellant failed to file his 2018 tax return after FTB's demand. In addition, the conditions required by the regulations were also satisfied because FTB issued an NPA on September 27, 2019, following appellant's failure to timely respond to a request for tax return for the 2017 tax return, which is one of the 4 taxable years preceding the 2018 tax year. For the 2019 tax year, FTB properly imposed the demand penalty because appellant did not file a return upon notice and demand, and FTB had previously issued an NPA for the 2018 tax year, satisfying Regulation Section 19133's requirement. For both the 2018 and 2019 tax years, appellant has not made any arguments as to why the demand penalty should be abated. As such, FTB's actions with respect to the demand penalty for both tax years should be sustained. With respect to the fourth issue, the filing enforcement fee was properly imposed for both tax years. When appellant failed to file his 2018 and 2019 returns in response to the demand letters, FTB imposed a filing enforcement cost recovery fee under Section 19254. Once properly imposed, there is no provision which would excuse the FTB from imposing this fee for any circumstances, including reasonable cause. As such, FTB's actions with respect to the filing enforcement fee for both tax years should be sustained. Finally, with respect to the last issue, interest was properly assessed for both tax years. Interest accrues because taxes are due and payable as of the original due date of the return. Section 19101 provides that if the tax is not paid by the original due date, or if FTB assesses additional tax and the assessment becomes due and payable, the law provides for charging interest on the resulting balance due, compounded daily. FTB's imposition of interest is mandatory, and FTB is not allowed to abate interest except where authorized by law. Section 19104 provides for the abatement of interest under certain circumstances if the taxpayer meets all of the requirements to show such an abatement. Appellant unfortunately has not alleged or established any of the statutory grounds for interest abatement. Therefore, interest may not be abated in this matter for either tax year. In summary, for both the 2018 and 2019 tax years, appellant has not demonstrated error in FTB's proposed assessment of additional tax penalties and interest, and FTB's actions should be sustained. This concludes my presentation, and with that, I'd be happy to take any questions the panel may have.
Hey, thank you, Mr. Meridian. And I'd like to turn it over to the panel now for questions, beginning with Judge Long. Judge Long, do you have any questions for the Franchise Tax Board?
This is Judge Long. I have no questions. Thank you.
Thank you. And Judge Kim, do you have any questions for the Franchise Tax Board?
No questions. Thank you.
Okay, thank you. And Mr. Larimer, before you begin your presentation, I wanted to briefly address your concern regarding the hearing transcript. As I stated earlier, the hearing transcript will be posted on our website, and you can submit a request to review the transcript and correct or update any items that you believe are inaccurate. And the form will be posted on our website as well, and that's at https://ota.ca.gov/resources/. And so you can just pull up the transcript, review it, and submit a request to correct any inaccurate items. And with respect to your concerns about the disclosure of private information set that's personally identifiable is protected under the Public Records Act, including telephone number, social security number, federal identification number, driver's license, financial account numbers, full names of children, etc. So hopefully that addresses both of your concerns. And I'm going to turn it over to you now. You have 10 minutes to provide your rebuttal or closing statement, and you can begin whenever you're ready.
This is Zoe. The central issue in this appeal is whether the FTP may sustain a tax determination against a California resident when there is no evidence of income above the filing threshold. The taxpayer has provided sworn statements and supporting documentation, and the FTB's own records confirm the taxpayer's compliance. I've shown it on time. Sorry. This case also raises a broader question of reasonableness and whether it is lawful for the state to disregard evidence, rely on incorrect data, and pursue enforcement actions against a compliant low-income resident. The appeal also concerns the reasonableness of the FTB's conduct. The absence of evidence, the use of irrelevant legal citations, and the repetition of incorrect data all raise serious questions about the state's handling of this case. The burden should not fall on the low-income resident to repeatedly disprove unsupported determinations. The FTB has not demonstrated that I earn taxable income for the years in question. I did not receive the FE study that was mentioned, unless it was the 2-page one. I have met every obligation under the law, provided sworn statements and documentation, and cooperated fully. The agency's continued reliance on incorrect data and irrelevant legal authorities lack foundation in both fact and law. I respectfully request the Office of Tax Appeals find in favor of the appellant, recognizing the evidence, the law, and prior judicial findings support my position. Thank you for your time and your consideration.
Hearing Officer Elsom, you're currently muted.
Sorry about that. Well, thank you, Mr. Larimer. I wanted to thank you for your presentations and your testimony today is very helpful. And at this point, again, we'll turn it over to the judges for any questions. Judge Long, do you have any questions for Mr. Larimer?
I have no questions, thank you.
Okay, thank you. And Judge Kim, do you have any questions for Mr. Larimer? Judge Kim, we can't hear you if you're.
Sorry. I guess I just had one question, Mr. Larimer. So FTB looked at your mortgage interest payments and they determined you had taxable income based off of that. My question is, how did you, or where did you get the funds to make those mortgage payments?
That's included in the exhibit. You'll also notice that in the 2015 and 2014, which is the data that they requested, that they said that they got this fee from the 4 or 5 years that they got the mortgage, you'll look that these are the years that were approved by the Franchise Tax Board and included all the information. So when I showed in my exhibit, I actually showed the real example of what's happening. And so you can actually figure it out in the exhibit.
Sorry, can you point to which exhibit that you're talking about?
Apologize. I think it's exhibit 13 or 12. It's the one that's basis off the FE study for the mortgage study, the 6-to-1, which is arbitrary. Sorry, let me look.
You've got plenty of time, Mr. Larimer, so take your time.
Yes, thank you. I think it was exhibit 13. Appellant worksheet analyzing income projections for 2013 through 16, which is what I was mentioning and talking about, based off the FTB's 2019 mortgage interest study. I was pretty detailed about how we go about doing this a better way, because I know that the AI is going to be doing this in the future, and I'd like to make sure that these things are fixed in the future. There was also a lot of things that was kind of going on that is we're not going to be talking about here, dealing with FTB actions, and it kind of messes with the data. So that was another thing that I was worried about. Does that answer your question? All of those things are there.
I'm looking at exhibit 13 and it's
okay. I need to pull it up then.
It's
Apologize. I have a lot of things on the computer here, as you see.
That's okay. I mean, I am looking at exhibit 13 and it's showing that you disagree with the income projection, but it's not explaining how you got the funds to pay for your mortgage during the tax year at issue.
Oh, apologize. I believe I said that the 2015 and 2016, the ones that were included in there, that information is also included with that, so that it'd be the same. I am paying in the exact same way. It makes sense, right? Nothing has
Mr.
changed.
Larimer, I believe what Judge Kim is referring to possibly is you had made statements that you received assistance from Alameda County and possibly from CalFresh, and or whatever information you have that shows that you were able to pay that mortgage interest and meet your living expenses.
Yeah.
Yeah, I believe he's referring to actual documents that show that rather than the analysis that you had used in contradiction to FTB's model.
I would have to know what date and time those things were that I made those statements and find out. It could be the 2019, it could be the 2018. Honestly, this is the first time I've heard of his presentation, and there's a lot of information in there that I was a little, I hadn't heard. I kind of heard about it, but it's different than the one that they sent me. So it's a little bit more detailed. I'm still processing it.
Okay, understandable. Judge Kim, did you have any follow-up questions for Mr. Larimer?
No, thank you.
Okay. Okay, thank you, Mr. Larimer. So I believe that we are have completed the hearing now, and we're ready to conclude. So I wanted to thank both parties for their presentations today. The panel of 3 here will meet and decide the case based upon the arguments and the evidence in the record. We will issue our written decision no later than 100 days from today. This case is submitted and the record is now closed. This concludes the hearing for the appeal of Larimer, and I'd like to thank everyone for